As we all know, the implementation of the DPDPA has been long overdue because of the impending notification of the rules. With the formation of the new government post-elections, the buzz on DPDPA has gained significant momentum. The Ministry of Electronics and Information Technology has indicated that the draft rules will be published for industry consultation and feedback in the next 30 to 45 days. In the run-up to the notification, some of the key pointers for Fintech should be assessing the applicability of the DPDPA and determination of capacity of the Fintech, that is, whether it should be categorized as a data fiduciary or a data processor. This is not just an assessment of existing business and practices, but will need to be a strategic decision for future businesses as well. It's going to be relevant for obligations and liability determination as well. Whereas a Fintech, you don't have a direct customer interface and access to personal data is purely ancillary to services like payment gateway services or data analytics conducted on behalf of other entities. A data fiduciary classification may not be relevant. However, if the same payments or transaction data is expected to be utilized for providing value-added services, this assessment is going to be crucial. One of the other key considerations is going to be setting the house in order, undertaking a gap assessment with respect to current personal data set, existing consent infrastructure, storage facilities, utilization, and also assessment of contractual arrangements with third parties for data leveraging or processing is going to be an important aspect. Taking stock of data, bundling them in regulated, non-regulated, personal, non-personal, and identifying the source of it, plus the ability to utilize and cross-sell financial services is going to be a key part of the assessment. While the exercise may be a low-hanging fruit for single financial services verticals, for businesses, financial services groups having multiple FS verticals or launching super applications, they need to have a grip over interoperability of this personal data across financial services verticals and also their tech verticals. An important aspect of the gap assessment is also going to be evaluation of the existing and prospective consent infrastructure to be deployed. Where Fintechs are sitting on legacy personal data, the requirement of a fresh consent versus mere notice will need to be analyzed. Also, setting up of new consent infrastructure would require a deeper engagement with the technology to come up with more innovative approaches to accommodating the consent components of informed, affirmative action, free, specific, unambiguous, and withdrawable. This will also need a balancing act for reducing friction in the customer interface. While the dust on the Gen AI settles and now the industry having a fair idea about what Gen AI can do for financial services, it's important that Fintechs realize and understand the interplay between DPDPA, the intellectual property norms, and also Gen AI. While the government releases its AI policy, it's also important that the liability associated with IP and data breaches is drilled into contractual arrangements for AI-based analytics. Lastly, while the government gears up for release of the draft rules and industry consultations, it would be good for Fintechs to have their thoughts ready on some of the key constraints they face in DPDPA implementation, and also suggestions on associated risk mitigation. This will help with running a meaningful consultation process.